Hey there. Today we're going to talk about the relationship of the states to each other. The last time I saw you, we talked about the national to state relationships and the Supreme Court as the umpire. Now we're going to talk about the relationship of the states to each other. The states weren't very nice to each other while they were Confederacy. They engaged in unfair trade practices. They were extremely competitive. Everybody was out for himself. And so the founders wanted to work in some provisions that would make the states more cooperative with one another. There are 4 provisions, and we're going to look at them, and we're going to try and do so in 15 minutes, because that's all I've got with this service. So, let's go. The first of the obligations that the states have to each other is called full faith and credit. This provision in Article 4 says that states must recognize and give legitimacy to each other and to the proceedings of all the other states. Basically, if the national government is going to guarantee that every state is a republic, which means that every state operates with free and democratic elections on democratic principles, and that they make their own laws using those democratic principles, then the states need to recognize the validity of this process for each other. And it doesn't mean they have to enforce, it just means they have to recognize validity. Okay? So you get, you adopt a child and you move to another state, you don't have to go through adoption again. Same with divorce. I used to say same with marriage, though that's getting a little more complicated now. But there's a host of things. The example I gave in the last unit was if you have a driver's license by Alabama, you can drive through every other state and they'll recognize that your driver's license is valid. Now the marriage example has gotten complicated, and the complication began in the 1990s when the state of Vermont passed a civil union law. And every other state decided that, hey, whoa, we don't want to have to recognize the marriages, because that's how they viewed this potentially, of same-sex couples. And the members of the Vermont legislature went on the news, all the morning shows, and they said, hey, no, this just applies if you live in Vermont. So if gay couples want to come here and register their union for the purposes of inheritance or making decisions in the hospital as next of kin or whatever, that's great, but they'll have to live in Vermont. In response, Congress passed the Defense of Marriage Act, which said that states didn't have to recognize marriages that were different from what their state wanted to recognize, so long as the state had some sort of legal provision or part of their constitution that defined marriage. Okay, that was in 1996. Fast forward almost 10 years to, or actually almost 20 years, excuse me, my math's off, to 2013, and the evolution of that process is that we now have 13 states that recognize gay marriage. We have a Supreme Court that made 2 decisions this summer, one which struck down the law that was known by its acronym of DOMA, Defense of Marriage Act, another saying that California, a voter initiative that defined marriage as just man and woman, the state courts there said that violated the state constitution, and therefore it was void, and the people that supported that law took it to the courts, and the Supreme Court said, hey, you don't have standing. You're not a party to this that's been harmed by it, so you can't bring this case to us. We won't make a decision. So what's going to happen with this? At this point, the court has not ruled that that DOMA violated full faith and credit, though that's what I think the constitutional problem is with that law. They've just said that the law itself basically violated the state's powers at this point. And so that's where it's left, and we will see where it goes from there. I think we are probably headed to a point where states will have to have more uniformity on this issue. I saw the news earlier today, this is Saturday, September 28th, 2013, that said that there was a ruling in New Jersey, who does not have a marriage law, they just have a civil union law, that they're going to have to recognize marriage. So I expect that we will eventually nationalize on this issue, and we will once again say that under full faith and credit, each state must recognize also the marriages performed in every other state. Now, the second obligation the states have to one another is called privileges and immunities. This one is a little harder to explain and to wrap your mind around sometimes. Basically, it says that, or the purpose of it is that states are supposed to treat the residents of other states equally and the same as they treat their own residents. So they shouldn't give any kind of preferences to residents over non-residents. They shouldn't have penalties for non-residents over those of residents. The example I often give is, if you get a speeding ticket in another state, your ticket should be the same regardless of whether you live there or not. The area that students often bring up on this is the out-of-state tuition issue with state colleges. That has been found not to violate this clause because the difference between in-state tuition and out-of-state tuition is equal to the amount of taxes that the state funds that university with per student. So basically it's the taxes that you didn't pay if you live somewhere else. So they've said that that's not a part of this. However, let's say that we're in Alabama. New car plant's opening. Mercedes is going to open up another plant down there in Vance, and they say that if you're a resident of Alabama, you get job hiring preference. That would more than likely violate the Privileges and Immunities Clause. They should give equal opportunity to people from other states that want to move here and have a job as well. Now, the third obligation states have to each other deals with criminal law. Those other two dealt with civil laws. And civil laws basically are contracts, family law, anything that's not criminal in nature, that doesn't violate the criminal laws of the state. In the area of criminal law, though, the obligation the states have to each other is something called extradition. And extradition is a process by where states are supposed to return fugitives to another state upon request. So let's say somebody escapes from prison in Colorado and they escape and they get to Texas. Then upon request of the governor of Colorado to the governor of Texas, Texas is supposed to return that fugitive. Okay, the Constitution, it really doesn't have any ambiguity in there. It doesn't say states should or states may. It says states shall return fugitives. That provision has been weakened over time, and it weakened really in the 19th century when northern states refused to return slaves under the fugitive slave laws. And so at that point, the court told them they didn't have to. And some states over time have used that as a loophole to allow them to say, well, I'm not so sure, you've got the death penalty and we don't, and so I don't want to return this person because, I just disagree with that. That's a reason that's been given sometimes. In order to try to close those loopholes, Congress has passed legislation that states have to set up extradition boards. So basically, if I'm a fugitive and I've escaped to another state and I say, oh, don't want to go back, don't send me back to Texas, they execute people all the time in Texas, and I'm going to have that potential punishment. I could request a hearing before the extradition board, and then I would have an attorney assigned to me, and I could present whatever evidence I wanted to before that board as to why I should not be sent back to the other state, and they'll consider that evidence and make a decision. Let's say they decide not to send me back. Well, the state that wants me still has a remedy. They can go to the courts and get an order that requires me to be returned back. So they're, for the most part, they do send it back. They do send back prisoners. I mean, who wants to keep somebody that has been known to violate, the laws of the state? If you keep them, then they might violate the laws of your state. So, you don't necessarily want them. But sometimes it's a complicated process. Now, the last aspect of this cooperation between the states deals with agreements, compacts, or contracts that states make with one another. Basically, we want the states to get along together. We don't want them going to war with each other. We don't want them feuding or fussing. And so we require these interstate compacts. A compact is an agreement or a contract. We also, however, don't want states doing secret stuff with each other. You know, that might lend itself to rebellion or insurrection. So their agreements have to be approved by Congress. They can't be done in secret. They've got to be approved by Congress. And most of these agreements have dealt with the use of precious metals or resources, water, cleaning up toxic waste, you know, things like that. It's usually a resource or cleanup issue. Occasionally they deal with other issues, maybe emergency assistance in bordering states or transfer of prisoners between states. There's an activity you guys can do where you look up compacts, and I would encourage you to do that activity because it does help you really understand this better and see what's going on with it. But there are a variety of ways that they do this. They have to be approved by Congress. If there's a dispute, the states say, hey, they're not abiding by the agreement. The Supreme Court would make a decision. If two states can't come to agreement, the Supreme Court, or I'm sorry, not the Supreme Court, Congress would appoint a mediator to conduct discussions and meetings between the states to reach agreement. And this, again, is a way to keep the states acting peacefully with one another rather than fighting with each other. So here's the what do you think. These are the questions to answer at the end of this lecture. Number one, is the obligation of full faith and credit workable in the 21st century? Or should issues like marriaging and professional licensing be uniform and nationalized? You know, this sometimes comes up with like doctor's licenses. Should they have a national license instead of state licenses? Same with attorneys. You know, should they have to pass licensing tests as they go from state to state, or should there be a national process? Two, do you think that fugitives requested under extradition requirements should be given that option to fight through extradition, or should it just be automatic? And explain your reasoning. And finally, if states are unable to agree with one another when disputes arise, is it better for the courts to make a decision and rule on it? Or should we push forward and make the states reach agreement, even if it takes more time? I look forward to our face-to-face. Hope you've enjoyed this lesson. Bye-bye.